Good afternoon to our listeners on Parliament Radio 105.5 FM, our viewers on the Parliament channel, and those of you joining us via the World Wide Web on the Parliament's website, www.ttparliament.org. We're also streaming on our YouTube channel, ParlView, that's ParlView. We're just a few seconds away from the start of today's sitting of the Senate. On the agenda, the Strategic Services Agency Amendment Bill 2016. We take you over now to the chamber for the start of the proceedings.
The Honourable, the President.
We welcome you to the 17th sitting of the Senate in the first session of the 11th Parliament that takes place on Tuesday, May 3rd, 2016.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Dennis Moses and Senators David Small and Jared Hadid, who are all out of the country. Honorable Senators, I have received the following correspondence from His Excellency the President Anthony Thomas Aquinas Carmona, SC, ORTT. The Constitution of the Republic of Trinidad and Tobago. Appointment of a temporary senator by His Excellency Anthony Thomas Aquinas Carmona, ORTT-SC, President and Commander-in-Chief of the Armed Forces of the Republic of Trinidad and Tobago. To Mr. Ronald Huggins, whereas Senator the Honorable Dennis Moses is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Ronald Huggins, to be temporarily a member of the Senate with effect from the 3rd of May 2016 and continuing during the absence from Trinidad and Tobago of the said Senator the Honorable Dennis Moses. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 2nd day of May 2016. To Mr. Gerald Ian Ramdeen, whereas Senator Jared Hadid is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Jared Ian Ramdeen, to be temporarily a member of the Senate with effect from the 2nd of May 2016 and continuing during the absence from Trinidad and Tobago of the said Senator Jared Hadid. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President, St. Anne's, the 2nd day of May, 2016. To Mr. Justin John Kerr. Whereas Senator David Small is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now therefore, I, Anthony Thomas Aquinas Carmona, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Justin John Kerr, to be temporarily a member of the Senate, with effect from the 3rd of May 2016, and continuing during the absence from Trinidad and Tobago of the said Senator David Small. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the Office of the President, St. Anne's, this 2nd day of May, 2016. Honorable Senators, Senators are required to take the oath, so please stand.
I, Ronald Huggins, have been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Gerald Ramsey, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, and will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Justin John Kerr, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Bills brought from the House of Representatives, petitions, papers.
Honorable Attorney General.
Much obliged. Madam President, I have the honor of laying the following papers listed on the order paper in my name. Quite importantly, the Criminal Procedure Rules 2016.
Leader of Government Business.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper and the supplemental order paper in the names of the Minister of Finance and the Minister of Foreign and CARICOM Affairs. The audited financial statements of the CPEP Company Limited for the financial year ending September 30th, 2013 and September 30th, 2014. The consolidated annual audited financial statements of Export TT Limited, formerly called the Business Development Company Limited, for the financial year ending September 30th, 2012, September 30th, 2013, and September 30th, 2014. The Privileges and Immunities CARICOM Implementation Agency for Crime and Security Impacts IMPACS Order 2016. The report of the Auditor General of the Republic of Trinidad and Tobago and the public accounts of the Republic of Trinidad and Tobago for the financial year ended September 30th, 2015. And finally, the public accounts of the Republic of Trinidad and Tobago for the financial year 2015.
Reports from committees, urgent questions.
Senator Mark.
Thank you, Madam President. To the Honorable Minister of Works and Transport.
And Transport.
Madam President, I have to read the question.
Oh, I'm sorry.
I'm sorry, is it? Given the recent announcement to implement LIDAR speed guns, LIDAR, sorry, thank you for the correction, LIDAR speed guns, could the Minister state whether consideration will be given to increase the speed limits on the nation's highway to avoid further traffic congestion?
Minister of Works and Transport.
Thank you, Madam President. The question hinges, it rests on this question of traffic congestion. I want to advise this Parliament and, of course, the Senator that traffic congestion is the result of a number of factors, the least of which might be people driving under or at 80 kilometers and 50 kilometers per hour in Trinidad and Tobago. Madam President, I wish to advise this House that the Minister of Works and Transport will continue to consult with the technocrats and experts in the area of traffic management. And after those consultations, a determination will always be reviewed and be made in respect of the designed and posted speed of the country's highways. We are prepared to consult with technocrats and experts outside of the ministry as well. All voices in this democracy will be heard. And these matters are under constant review. After these reviews are taken into account, then the priority for us in the Ministry of Works is the question of public safety, which I give the Honourable Senator the assurance will never be compromised.
Senator Mark.
Madam President, through you, maybe the Honourable Minister may wish to share with this House how the implementation of this particular project is going at this present time. Can he bring us up to speed, seeing that today is the first day of its implementation? Could the Honourable Minister help us?
And today is not the first day of its implementation. This was actually, the order was signed by yours truly last Friday. It was published as well last Friday. It took effect since then. So I hope the Honourable Senator was observing the law since then and even before. Madam President, the situation is that the law of Trinidad and Tobago is now that speed measuring devices are now in use to detect excessive speeding on our nation's roads. And the reason for that is to detect these offenders and to prosecute them. And of course, all with the view of public safety constantly, Madam President.
Senator Mark, you're giving way to Senator Amin.
Thank you, Madam President. I want to ask the Minister in his consultation, I know that previously technocrats had looked at the area of e-ticketing and different technologies with regards to speeding and other offences on the road. Can you say whether your ministry or you or the government has given any consideration? I mean, the speed guns is a pretty well-established technology. I don't want to say old, but there are other very modern methods with regards to e-ticketing and reducing speed and dealing with driving offences in general.
Thank you very much. That matter is, of course, under active consideration as we speak. We are reviewing the amendment to the Motor Vehicle and Road Traffic Act, and that matter is under active consideration and will find itself before you for debate very shortly.
Questions on notice, questions for oral answer.
Madam President, I just want to assure this House that the government will be answering all 3 questions listed on the order paper today.
Senator Mark.
Yes, thank you, Madam President. Question number 40 to the Honourable Minister of Labour and Small Enterprise Development.
Minister of Labour.
Thank you very much, Madam President. In response to my honourable senatorial colleague, I wish to forward the following information. 836 workers, Senator Mark, not 830, 836 workers were identified for retrenchment in notices submitted to the Minister of Labour and Small Enterprise Development in accordance with the Retrenchment and Severance Benefits Act during the period 11th of September 2015 to January 2016 as follows. 1. Alston's Building Enterprises Limited, 6 workers. Anthony P. Scott Company Limited, 15 workers. BP Trinidad and Tobago LLC, 7 workers. Brickforce Limited, 28 workers. Bristow Caribbean Limited, 13 workers. Columbus Communications Trinidad Limited, 19 workers. Constructura OAS, 317 workers. Crown Packaging Trinidad Limited, 16 workers. Fair Chance Racing Service 2006, 39 workers. Goodwood Racing Service, 15 workers. Gulf Mark Marine Trinidad Limited, 1 worker, and that is unusual. CaterServe Limited, 14 workers. Kenson Operational Services Limited, 12 workers. Metal Designs and Concept Limited, MDCAM, 6 workers. Methanex Trinidad Limited, 5 workers. OCM Group Executive Corporate Services Trinidad Express Newspaper, 42 workers. Royal Bank, RBC Royal Bank Trinidad and Tobago Limited, 95 workers. Regency Recruitment and Resources for Repsol E&P TNT Limited, 15 workers. Schulenberger Trinidad Incorporated, Schulenberger. I am a Trinbagonian, Madam President, and with a foreign company, I'm entitled to make such a mistake. 1 worker, which is unusual because the Act calls for informing 5 and over. Scotiabank Trinidad and Tobago Limited, 35 workers. Superior Energy Services Trinidad Limited, 10 workers. Tissues Limited, 10 workers. Trinity Exploration and Production Services Limited, 48 workers. Trinsulate 2 Caribbean Limited, 12 workers. University of Southern Caribbean, 37 workers. Weatherford Trinidad Limited, 17 workers. And West Shore Medical, 1 worker, bringing it to a total of 836. Madam President, it is difficult to provide data on the total number of workers actually retrenched during the period 11th of September 2015 to January 2016, as there is no statutory provision for reporting such information or providing formal notice of retrenchment where an employer proposes to terminate the services of less than 5 workers. It is in this context, Madam President and honorable members should note that the applicable legislation is being currently reviewed in consultation with the stakeholders. And that is to say, through you, Madam President, to Senator Mark, the review of the Retrenchment and Severance Benefit Act. That process of consultation will be held on the 18th of this month.
Madam President, through you, can I ask the Honourable Minister, in light of the growing spate of retrenchment and layoffs, whether the Honourable Minister sees the need to fast-track the revision of the Retrenchment and Severance Benefits Act and bring such changes as quickly as possible to this Honourable House for its approval, well, debate, and ultimate approval. Do you think that there is need to speed up the process, Madam President, through you?
Minister of Labour.
Thank you, Madam President, to the Honourable Senator. I don't know that today is the 3rd of May. The consultation would take place the 18th of May. And we have to go through that period and that process of consultation, because at the end of the day, we would not want it to be said, as has been said of my predecessor, that he brought a piece of legislation to this House without going through the consultative process. So once a consultation has been completed, the technocrats at the Ministry of Labour, they will try to pull the strands together into a working document that we will send back out to ask the participants, the stakeholders, did we get it right? Is this what we agreed upon at the consultation? Then it comes back to the ministry. Then I would have to take it to cabinet by way of a cabinet note, and the cabinet will deliberate on it and decide on the time frame for it coming before this honourable House. But rest assured, it is of concern to this government, and we will be working as speedily as possible. And lastly, Senator Mark, you will agree, after being in office only 8 months, for such a piece of legislation engaging the attention of the stakeholders is really one worthy of worth. Yes?
So, as the Honourable Minister, whether, well, apart from that very important piece of amendment to the Retrenchment and Severance Benefits Act, whether there are any other measures that the Minister intends to pursue in an effort to address the chronic job loss, the chronic job loss, or loss of jobs, I should say, that workers are experiencing quite frequently in TNT. Is there any other measure that you'll want to examine or you'd like to share with this honourable House to ease the burdens of the working people as a result of layoffs and retrenchment?
Labour.
Yes, thank you, Madam President. As a matter of fact, Honourable Senator, there is a piece of legislation that the Minister of Labour, I intend to work diligently to bring before the Cabinet and this House, and it has to do with the basic conditions of employment code that will be converted into a bill and hopefully legislation, because I believe at the personal level, it has not engaged our Cabinet as yet, but at the personal level, that This country requires basic conditions so that all workers in Trinidad and Tobago, when they go out there, they know they will be eligible to enjoy certain basic conditions of work. So that a consultation has been carded. My permanent secretary and the rest of our team, we agreed on having a consultation on the basic conditions of work or basic conditions of employment code on the 29th of June, the 29th of next month. As a matter of fact, you are the first person I'm sharing it with, Senator, after the team at the ministry.
The Honourable Minister whether the unemployment insurance fund, which I understand exists in Barbados, I may be wrong, but that's what I understand, whether that is a measure that you would be looking at so that when workers are retrenched or laid off, there will be some kind of cushion or buffer to take them through, if between, let's say, 6 months to a year before they can find meaningful employment through training and retraining. Is that a measure that you would also wish to consider as a buffer to ease the burdens on behalf of the working class?
Minister of Labour.
Thank you, Madam President. To the Honourable Senator, that suggestion was placed before the party that I belong to and does form part of the policy of the government to put in place all mechanisms that can assist workers during good times and bad times. As a matter of fact, that suggestion has been mooted by the leader of the Joint Trade Union Movement, and I have absolutely little doubt that coming out of that consultation on the 18th of this month, undoubtedly that would form part of the discussion and the conversation.
Senator Mark.
Thank you very much, Madam President. Question number 41 to the Honourable Minister of Education.
Minister of Education.
Madam President, the Concordat came into being in 1960, more than 55 years ago. Since that time, a number of questions have been raised by stakeholders and the members of the public in relation to the selection of students, the teaching of religious education, and the funding arrangements for repairs and the construction of denominational schools inter alia. During the recent national consultation on education, feedback was sought from all stakeholders on both the Education Act and the Concordat, and how the administration of the education system can be improved. Arising from this feedback, the Ministry of Education intends, subject to Cabinet's approval, to actively engage denominational boards in further discussions in order to ensure that the mutually beneficial and cordial relationship that exists between the denominational boards and the government can be improved and strengthened where applicable to provide the best educational opportunities for the nation's children. Thank you.
Senator Mark.
Could I ask the Honourable Minister, before these consultations were to commence, whether the government intends to issue a policy document so that the public of TNT can, in fact, understand what is the government thinking on the way forward as it relates to the future of the Concordat before you embark on consultation? Would there be a policy document issued by the Ministry of Education on this very important subject?
Minister of Education.
Madam President, it appears to me that Senator Mark wasn't listening attentively when I spoke, because I explicitly stated that we had a national consultation on education, which included discussion on the Concordat. What Senator Mark is trying to get from me now is perhaps another consultation. I would like to inform this House that the report on that consultation, that national consultation, will be ready in a few weeks' time. And then, after this taken to Cabinet, we will relay to the general public the contents of this Concordat. I would like to say that it was based on extensive discussion that we had during this consultation.
Senator Mark.
Question number 42 to the Honorable Minister of Trade and Industry.
Minister of Trade and Industry.
Thank you, Madam President. Subsequent to the reading of the 2016 budget on October 5, 2015, and the announcement by the Minister of Finance on the reduction in the rate of value-added tax from 15% to 12.5%, an interministerial committee was formed to oversee the implementation of this measure. The interministerial committee comprised representatives of the Ministry of Finance, including the Customs and Excise Division and the Board of Inland Revenue, and representatives of the Ministry of Trade and Industry and the Ministry of the Attorney General. Extensive consultations were also held with key industry stakeholders, including the Trinidad and Tobago Manufacturers Association, the Trinidad and Tobago Chamber of Industry and Commerce, and also the Supermarkets Association of Trinidad and Tobago and the Food Distributors Association of Trinidad and Tobago. Therefore, Madam President, the major stakeholders and hence the implementers of the amendment were fully apprised of the measures being proposed by the government. This was a critical element of the process to ensure consensus and buy-in of the measure prior to actual implementation. Further, in order to ensure that there were no misconceptions or miscommunication about the new VAT regime, a number of measures were implemented to ensure compliance by businesses and ensure that instances of profiteering or price gouging by businesses were mitigated. These measures included the establishment of a VAT hotline, a VAT email address, inspection of business places by the field officers of the Consumer Affairs Division of the Ministry of Trade and Industry. A series of public awareness and promotional activities and publications by the Consumer Affairs Division were also implemented, included the publication of a list of prices of various items prior to the change in the VAT regime and the prices of such items after implementing the new VAT regime. The VAT hotline and the VAT email system was set up to field calls and emails from members of the public to clarify any matter that was unclear to consumers and to business owners and to address any inconsistencies or violations of the law. These measures were quite instrumental in the filing of complaints against unscrupulous businesses that were not following the new VAT regime. Such complaints were either investigated by the Consumer Affairs Division or transferred to the BIR, the Board of Inland Revenue, or for immediate attention. As at Friday, April 29, 2016, over 100 phone calls and over 50 emails were received and responded to by the Ministry of Trade and Industry on issues relating to the new VAT regime that became effective on February 1st, 2016. The Consumer Affairs Division also engaged in awareness-building campaigns to ensure that consumers and business owners were fully aware of the law. To this end, data and information relating to prices, brand names and outlets, etc., were published on a periodic basis to highlight the prices of selected items by selected businesses by product and brand name. The Consumer Affairs Division also conducted a series of interviews on Music for Life Radio 107.7 and with the Business Guardian newspaper. The information published by the Consumer Affairs Division were geared towards informing consumers of the prices on offer by various businesses so that consumers can make an informed choice and choose to purchase items from those outlets with the lower prices and abstain or boycott those with the higher price. Madam President, while there may be a small percentage of unethical and unscrupulous business owners that choose to break the law, the majority of business owners are compliant with the new VAT regime. I also wish to assure consumers that the field officers of the Consumer Affairs Division and the Board of Inland Revenue will continue to be present in the field to monitor and ensure that businesses continue to uphold the law and that the pockets of businesses that continue to breach the law will be penalized accordingly. Thank you.
Mark?
Madam President, based on the various devices and mechanisms outlined by the Honourable Minister to safeguard the interests and the rights of consumers, could the Honourable Minister indicate to this Honourable House how many business owners who have been engaged in price gouging have been charged and have been brought before the courts of Trinidad and Tobago thus far?
Yeah, thank you, Madam President. This is a matter for the Board of Inland Revenue, but to the best of my knowledge, I do not believe that any business houses would have been brought before the law. Certainly, there were complaints very early, and mainly two or three of those. Most people wanted clarification on prices, but two or three of those complaints pertain to businesses who we felt may have been offending the law, and those matters were referred to the Board of Inland Revenue. Quite likely, those businesses may now have conformed and are acting within the law. But we continue to be on the field, the Consumer Affairs Division, doing about reviews at about 40 supermarkets per month and other business houses, included hardwares as well, checking on prices and publishing in all of the daily newspapers at least once a month, but also bearing in mind the cost of advertising, certainly on social media every month.
Public business, government business, bill second reading.
Honorable Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Strategic Services Agency Act, Chapter 1506, to expand the functions of the Strategic Services Agency now be read a second time. Madam Speaker, Madam President, took me a long while to get used to saying Madam Speaker, and now I have to revert to Madam President. I'm very pleased to be back in the Senate this evening, and more particularly pleased to pilot before the honourable members of this House, and through you to the national community, a very important piece of legislation, one which has root in burning issues that grip our country in Trinidad and Tobago right now. Any bill that comes before Parliament must meet with certain criterion. We're assembled here as a Parliament, bicameral structure that we are, pursuant to Section 53 of the Constitution, as we are obliged to make laws for the peace, order, and good governance of our country. This bill has passed through the House of Representatives, but one may say that, as with any bill that is simple majority legislation, that the real test to be had is in the Senate. After all, there are other minds than the bipartisan politics which grip our country, and it is with that focus in mind that persuasion has to be had, not so much to the numbers that you have in any one house, but also to gripping to the bona fides of any bill that you bring. All law must be democratic within the context of our Constitution. All law must be proportionate within the context of our Constitution. There has been an argument offered by members of the opposition in the House below, and without holding members opposite me now to the same point of view, there has been a statement that the law that we now seek to bring is one which traverses on constitutionality. It is for that reason, therefore, that I must freeze frame on a few basic issues before this House, and I propose to do so in the following fashion. One, to speak to the legitimate aim of the legislation now before us. Two, to speak to the manner in which any rights which could be potentially affected are being traversed in fact or potentially. And thirdly, to speak to the proportionality of the intrusions as may be alleged, as may be in fact. That must be done in a context, Madam President. And the context is seated in the very starting point of what this bill is about. This bill seeks, in a very short form, 5 clauses only, essentially to amend 3 clauses in the SSA bill, the Parent Act. This Parent Act, as we know, was passed in 1995, considered in 1994, and was on the back of a considerable amount of work until then Minister of National Security John Eckstein, on the 11th of September 1995, piloted legislation which we now 21 years later now seek to adjust. Specifically, we are inviting members to recognize that this legislation has been around for a very long time. We seek, in essence, if I were to summarize the points, to attenuate the law before us now by materially amending the definition of what is the subject matter of the parent bill into a formula of what we now call serious crime. Members will note that we have circulated not just the very skinny version of the bill, but I have asked as Attorney General that the Parliament distribute out marked up versions of the legislation so that the amendments that are to be considered can be factored alongside the parent law. After all, we must make intelligible sense of the proposals which we are putting before you, and the law must not be considered in a vacuum, but in the context of the amendments. We ask the Honourable House specifically to consider a definition of serious crime, and we have asked that this definition include offences relating to homicide, treason, terrorist acts, terrorist financing, hijacking, kidnapping, trafficking in persons, trafficking in children, gangs, illicit trafficking in narcotics, psychotropic substances, precursor chemicals, dangerous drugs, corruption, money laundering, smuggling, arms and ammunition, chemical, biological and nuclear weapons, and weapons of mass destruction, computer misuse, cyber crime, transnational crime, or any offense which carries a penalty of not less than 5 years imprisonment. We have asked that members consider that we take the definition of serious crime, we essentially substitute this broad-based definition throughout the body of the Act. We allow for the SSA, which has a proven and established architecture for now 21 years, to be allowed as the springboard for intelligence-based agencies, specifically to coordinate the collation of information gathering in the context of the existing law, and that therefore the purview is now widened. We say that this law does not stand alone. We specifically recognize that this law must be read alongside all of the other laws that interact directly with it. They include customs and excise enforcement and operation, customs legislation. They include specifically the position of, and I've actually listed it so honourable members could have reference to it, the Constitution of the Republic of Trinidad and Tobago, the Proceeds of Crime Act, Trafficking in Persons Act, importantly, and I'll spend some time on this, the Interception of Communication Act, the Financial Intelligence Unit of Trinidad and Tobago, the Dangerous Drugs Act, Anti-Terrorism Act, Firearms Act, Police Service Act, Defence Act, and specifically, we start to drill down into computer misuse, data protection, Administration of Justice Deoxyribonucleic Act 2011, and then we factor serious crime as now broadened into this SSA bill by asking members to put it into operation, articulating with those laws. We say specifically that we want this law to operate in the very few sections that stand as the existing law. The existing law is, after all, only 14 clauses long, 14 sections long. And we say that there is adequate balance in amending this definition of serious crime and putting it into effect into the law for a number of reasons. We say that there is no enshrined right that is being infringed. We say specifically that there is no right to privacy, as some people allege exists in this jurisdiction, but which our courts do not recognize, specifically so. Our Constitution does in Section 4C recognize the right to private and family life. Our courts are replete with judgments that say that the right to privacy is not per se a right. Our common law recognizes a right which says that there is breach of confidence. Our equitable jurisdiction has most recently, in certain cases, recognized an equitable jurisdiction to the protection of certain privacy issues. but the debate is still ongoing with respect to our right of privacy per se. We say that even if one were to take it as an allegation that there is an intrusion into Section 4C of the Constitution, that we do not need to look to a 3/5 majority argument because the law is proportionate, and taking a veil of dicta, such as Baroness Hale has offered for our consideration, such as many of our cases have recognized, be it Surat, be it any one of the decisions, that we simply need to look to whether there is a proportionate safeguard to the operation. So when one takes the definition of serious crime, when one asks for the functions of the SSA Act, as we are now broadening through an amendment to Section 6 of the legislation, when we take the functions of the Act, we apply it to the purview of surveillance, which is one of the functions only of the SSA, that in fact we must read that management of that issue alongside the laws which govern how one intercepts communication, how one articulates the operationality of any issues arising from that. And specifically, I invite the honorable members of the Senate to look at the argument that society is now discussing. This debate, which happened in the House of Representatives, was an interesting one. We received from the opposition no suggestions for amendments, no written concerns. That debate, in fact, the first reading, second reading in the House was on the 16th of March, the third reading and passage on the 15th of April. I understand, however, that the opposition has in fact written to all independent senators, that the opposition has also, I say as I understand, I could be wrong. I understand that the opposition has written to members of the diplomatic and consular corps. I could be wrong. This is the information that has come to me. But I wish to simply say that the government of the day has not received a single submission from the honourable members opposite. However, any government that intends to pass legislation is obliged to listen to the views of all and to work together with the legislative aim of coming up with the best laws possible. Madam President, when we look to the issue of serious crime, I think it's incumbent to just stick a pin in the argument for a moment before we look to how the amendments will be operationalized in the existing law, if it is that this bill passes muster here. We must look to some of the ills or mischiefs in society right now. And permit me for a moment to refer to a few examples. The Financial Intelligence Unit in their 2015 report looked at the dollar value of monetary transactions passing through it and specifically stated in their report that $3.665 billion of monetary value were considered. In that context, I'm able to say from information received at the ministry that in Trinidad and Tobago, we have had 68 seizures only. The value of money detained but not seized is $4.2 million or 121,000 US dollars. The amount actually forfeited from roughly $3.7 billion is a massive sum of 250,000 TT dollars. When we look at money laundering, I'm able to say 10 offenses are currently before the court only. When we look at suspicious transactions reported as disaggregated, we see in 2011 there were 303, 2012 258, 2013 554, 2014 617, 2015 609. When we look at murders, in the period 2010 to 2015 going through each year, they are as follows. 485 for 2010, 354 for 2011, 383 to 2012, 408 to 2013, 403 to 2014, 2015, 410. A steady rise up after the state of emergency effects had rebalanced. Detection and conviction rates for homicide in the period 2008 coming forward, 2008, 15.9%. 2009, when Special Anti-Crime Unit came in, 26.8%. In 2010, they were stopped, the Special Anti-Crime Unit, in April 2010. The figures attenuated down to 22.8%. In 2011, 21.9%. In 2012, 16.6%. In 2013, 10.3%. And so the trend falls down. We heard one of the members in the House say on the bench opposite that the figures now stand close to what inflation rates look like. That is under 10%. The low has actually been as bad as 3% in the period 2010 to 2015, including murder-homicide. When we look at woundings and shootings, 2013, 542, 2014, 558, 2015, 600, steady increase. Let's look at another mischief in our prisons. Some of us have heard statements made in our prisons consultation. We heard, in fact, and I wish to take this opportunity to address an issue in the public domain. The information that I put into the public domain then, as I will do now, came to me in respect of items recovered in our jails from the Commissioner of Prisons himself in writing. So I'm not quite sure what the Prisons Officers Association are speaking about in contesting some issues. Secondly, as a matter of fact, items including gun, ammunition, firearm projectiles, marijuana, cocaine, SIM cards, telephones, video recorder cards, all of these were found in their thousands. Thirdly, as a matter of record, on coming into office, we implemented the jamming technology into the jails, grabbers and jammers, previously in a drawer. We intercepted in a 99-day period in one jail and in a 30-day period in another jail 1,535 calls coming from in the jail going outside, 126,247 text messages coming from inside the jail going outside. In another jail, 379,864 phones were jammed, text messages blocked. In this other jail, 48,581 text messages blocked, originating from in the jails and coming out. Now, I don't do that for a pat on the back. It is, after all, common sense that one should apply the laws available or technology available to you. I do that to state and mark the condition that Trinidad and Tobago finds itself in. Allegations of corruption abound everywhere. They have found themselves in our fourth-round mutual evaluation conducted by the Caribbean Financial Action Task Force, which at its plenary in June 2016 will be invited to consider what is now in the public domain, whether Trinidad and Tobago should have sanctions visited onto it as a result of being put into enhanced follow-up. Cut that clean. See FATF, which is a 27-basin country, which applies the FATF Forte recommendations, says that Trinidad and Tobago's efficacy in relation to applying its laws is woefully short. They say you may be technically compliant in some laws, but the effect of your laws being applied are woeful. I think that the figures I've just put statistically beforehand demonstrate that that may perhaps be true. Therefore, when one considers serious crime as now defined, are we really doing something that is mischievous in allowing the SSA the ability to have purview of what we have now defined as serious crime? In considering that, I would like honorable members to refer to the annual reports of the Strategic Services Agency for 2009, 2010, 2011, 2012, 2013, 2014. And in those written annual reports, you will note in writing that the SSA has in fact been involved, as I read from page 6 of the 2010 report. Within the first quarter 2010, the agency continued to pursue issues relating to the combating of money laundering, financing of terrorism, etc. When we looked at another report, that the resultant policies the nature of TOC is inclusive. They are looking at illicit trafficking in drugs, trafficking in arms and ammunition, explosives, trafficking in person smuggling, migrants, money laundering, corruption, terrorism, kidnapping, cybercrime, organized criminal groups. So these are what the reports tell us the SSA were actually doing. And now we come to the Parliament and we say, listen, let us take avail of the state of Trinidad and Tobago. Let us look at all serious crimes. Let us look at what the SSA was in fact doing, and let us now legislate it. Another mischief before us, by way of a legitimate aim, is specifically that as a matter of fact, Trinidad and Tobago has a national operations center which was specifically the subject of a cabinet note under the last government, which created the National Operations Center. It is minute number 1005, dated March 13th, 2014, coming out of a UNC government, which specifically set up a National Operations Center to take control of operational assets which that entity took. Specifically, operational assets provided for in the budget of the Office of the Prime Minister to the tune of $80 million a year, which included flying of helicopters, boots on the ground, CCTV cameras, and the NOC, under the previous government, purchased from Huawei Technologies surveillance equipment and facility equipment to the tune of close to $1 billion, all under the National Operations Center under the Office of the Prime Minister. By cabinet note, the Operations Center also included specifically CCTVs for surveillance, which the NOC had direct access to, and which the predecessor NSOC, as it was called, and then relabeled NOC, had in active operation. And the documents to prove this have been found in the National Security Council minutes and notes under the Office of the Prime Minister, as the Prime Minister heads the National Security Council. Further, Trinidad and Tobago had a National Training Academy. Specifically, we had a National Security Training Academy, which in fact has now effluxed. And that academy was a combination of ventures between the Ministry of Education, Tertiary Education, and the Ministry of National Security. Question to the Honourable Senators through you. Is it appropriate then to now come to the Parliament and say specifically as we do in the modelled legislation before us now, if one were to look to Section 6, as it is proposed to be amended by Clause 4 of the bill, we look to subparagraph B, Roman 5, and where we see we are adding strike training only for staff and insert training for staff of the services. Services is defined in the bill as customs, TTPS, all agencies falling under the purview as defined in the legislation. And we now ask, is it appropriate as a nation to leave a billion-dollar enterprise called National Operations Center without parliamentary scrutiny previously had to it, without management and oversight? Is it appropriate to take a national academy not under one umbrella and just leave them in the cold? Or is it appropriate to do as we do now and to say, take avail of these assets, take avail of the work that was being done, bring it under one umbrella and park it under an SSA? But I found it quite interesting to listen to members opposite me speak to some very interesting facts. And members opposite would be very surprised to learn, or perhaps members would be invited to look at a few specific publications produced under the hand of the last government. I refer to Policy to Establish National Security Institute of Trinidad and Tobago. It's a document, a strategic interagency learning model, 20th of the 9th, 2012. It says, I refer members also to another very interesting document produced under the hand of the last government, Policy on the Amendment of the Strategic Services Agency, produced by Carlton Denny, chairperson, Margaret St. George, Keith DeFreitas, Golda Chase, Alexa McKell, Susan Alfonso. I also refer members to another policy document on the amendment of the Strategic Services Agency Act produced by that last government and which spoke to the NOC as well. In writing in these documents, words such as this proposal was developed against the backdrop of Cabinet's decision recorded in Minute 373, February 2011, to dissolve Special Anti-Crime Unit and instead establish National Intelligence Agency. It goes on specifically to talk, for instance, in another section of it, issues specific to the SSA agency. It says specifically, the SSA relevance lies in its ability to effectively formulate a unified policy and coordinate national strategic response to illicit sale and trafficking of drugs, etc. Its establishment made Trinidad and Tobago one of the leading regional and hemispherical exemplar states that responded to the call for demonstrating a shared responsibility. As a result, SSA was placed alongside other regional hemispheric partners. SSA became operational 1st July 1996. It functioned as a central coordinating body for dangerous drugs, etc. Functions of the SSA are stipulated as follows, and it recants. It goes on to say that the SSA and the NOC, it speaks to SORT and NOC coming after SORT after the cancellation. It says that the NOC, formed by the National Security Council by that minute, took responsibility for, listen to this, direct action team, canine agency, air assets, former SORT assets. NOC's formation took place during state of emergency declared on 22nd August 2012. It would appear that functioning began even before that cabinet minute. NOC's operation room provided a feed from CCTV cameras. 3 to 4 helicopters operated by the NOC. NOC operated with an informal configuration, being granted cabinet extensions. It goes on to speak as well that the National Operations Center should be put into, listen to this wording, rather than reinvent the wheel, it is proposed that inspiration be drawn from the proven legislation establishing the SSA. The SSA Act has provided for sound administrative and accountability structures and has worked for over a quarter of a century. All UNC documents. It goes on to speak in detail about the appointment of an SSA director, and lo and behold, shock beyond to me when I realized that the director as appointed under the 3 recommendations of the last government, you know what the director's appointment was? Conditions and terms? Keep it as it is in the SSA Act. It is proportionate. It doesn't require 3/5 majority. It is excellent law. It is balanced in proportionate measures, which I will come to in a moment. So imagine my surprise when I listen to members opposite me now, not now, in another place, tell me chapter and verse of what I should be doing to consider amending this law. But apparently, Madam President, it is not do as I do. It is do as I say, not as I have written, not as I intended to do, not as I bothered to write down and pay millions of dollars for. It is do something else instead. And what the last government had before it was over and over again this nagging issue of how to formalize issues. I want to put onto the record the international agencies which Trinidad and Tobago cooperates with have insisted that they wish to do business with a country that has a formalized structure. Listening to our international partners, we have accepted the wisdom of that argument, and we are taking forward now, by way of persuasion for acceptance before honorable senators, a structure of the SSA which is one which we think is better by accepting assets only in relation to intelligence and never in relation to operationality, because the architecture of the bill before you as amended works upon the back of the existing law. The existing law says all functions must be intelligence driven. As amended, it's the same. It says all actions are to be handed over essentially when you look to the implication of the law, and to be dealt with by the Trinidad and Tobago Police Service or other investigative or prosecutorial agencies. We don't change that. We instead provide a filter for de-siloing information because it is a known fact that Trinidad and Tobago has in operation right now a number of entities which are engaged in surveillance. Proof one for that fact is that the Interception of Communication Act specifically says Trinidad and Tobago Head of Defense Force has the authority to be an authorized officer to intercept communication. The Trinidad and Tobago Police Service has the authority to intercept, and the Director of the SSA has the authority to intercept. That's the law that was passed in 2010 by the last government, which we supported because we agreed that that should be so. It is a matter of fact that the agencies that also have surveillance right now under those three heads includes Defense Force, Intelligence for the FIU through the FIB, Financial Intelligence Bureau, the Anti-Kidnapping Squad, Criminal Investigations Division, Homicide Bureau, Cybercrime Unit, Special Branch, Organized Crime and Narcotics, Prison Service Intelligence, Counter-Trafficking Unit.
15 minutes.
But, Madam President, it is important to recognize honorable senators through you that surveillance is not the only function of the new bill. It is coordination, it is production of reports, it is production of audit capacity. Surveillance, if it is to be had, must only ever be done under the interception of communication legislation. Specifically, I invite honorable members to reflect upon Section 6 of the Interception of Communication Act, which specifically says all interceptions are unlawful unless subsection 2 provides the exceptions. It is done pursuant to a warrant, or it is done pursuant to certain activities which are in fact accepted out, and those include, if you just give me a moment, and if those specifically include under the Interception of Communication Act, and permit me to refer members specifically to it. Communication intercepted in the interest of national security, that's anything in national security, for the prevention or detection of an offense for the penalty of which is 10 years or more, I'll come to that point, for the purpose of safeguarding the economic well-being of the state, that is wide open to interpretation, for the purpose of giving effect to the provisions of international mutual assistance. And any communication so intercepted must be done in accordance with Section 8 and Section 11 of the Act. Section 8 describes the circumstances which you go to the judge for. Section 11 describes the circumstances where you do it in an emergency. Under the Interception of Communication Act, all information intercepted must be recorded, and if it is not to be used, it is to be destroyed in accordance with Section 20 of the Interception of Communication Act. Interception includes any form of interception. Music, listening, any form, visual, it is intercepted here within the definition of what interception is. The SSA Act, as it's now proposed to operate, is not reinventing the wheel. The Interception of Communication Act works with that. The issue of databases. Databases are not new. A database, if it contains personal information or sensitive personal information, may potentially be dealt with by the Data Protection Act. The Data Protection Act specifically excludes that type of application for criminal records or law enforcement activities or anything to deal with crime. If it is that samples are collected by way of DNA, etc., it's not the SSA that collects that. It has no operational function. The SSA asked the Trinidad and Tobago Police Service to go and do their job, and the Administration of Justice Deoxyribonucleic Act then prevails as to the holding of information that may be caught there. So, honorable senators, don't be persuaded by an argument that this is some new power. The fact is, serious crime, and I told you I would address the 10-year point, in the Interception of Communication Act, they specifically allow for offenses 5 years and under to be dealt with. But if you want to intercept anything under the Interception of Communication Act, you must strictly comply with the law. The law exists. Why have I raised that? Because, honorable members, the fact is, proportionality is to be factored against what is the balance to the power you're giving. So that's one balance. the interarticulation of laws that exist. What is another balance? Isn't it laudable, honorable members, to apply the strength of the Constitution to the new agency in its broadened capacity by inviting the Auditor General under Section 116 of the Constitution to have purview of all of this? Isn't it also laudable to allow that public scrutiny to be backed against when we are looking to who works for the SSA? Who works for the SSA? The legislation tells us, the Parent Act, that it is members who are either contracted officers or members who are public officers so seconded or police officers so seconded. Police officers seconded have the weight and strength of the provisions in Chapter 9 of the Constitution. You have public officers so seconded having Chapter 9 of the Constitution. And what is that? Police Service Commission, Public Service Commission, the powers and authorities that vest there. On top of the police, there is the PCA, providing check and balance, police service rules. Isn't it laudable, therefore, to recognize the strength and support provided by giving constitutional structure to this? Isn't it also laudable, honorable members, to take conscious reflection of the improvements we made as a parliament to the standing orders of the Senate and the standing orders of the House? Let's use the Senate alone. Isn't it true Standing Order 93 allows for a Joint Select Committee on National Security? Isn't it true that Section 103, Standing Order 103, allows for the powers of all Joint Select Committees to be applied there? Can't you therefore call for papers, call for persons, call for interrogation, invite sanctions? Isn't that proportionality and structure to law that we now propose? Isn't it true that the statutory services, statutory authorities fall under purview of the Parliament? And apart from the National Security Joint Select Committee, you also have the Statutory Authorities Joint Select Committee. And that is where the legislature provides a countervailing balance against the executive. The documents produced by the last administration speak to absolutely no need to interfere with the director's appointment as has prevailed for 21 years in the SSA Act. They had an opportunity in 2010 to amend it when we did the Interception of Communication Act. They had an opportunity, we as a country, in 2010 to say we don't want the director of the SSA to be involved in surveillance, but we didn't do it. Why? Why did we as a country not do that? Why did the then government not do it? Because the Interception of Communication Act has a balance of judicial scrutiny, destruction, and who under Section 20 of the Interception of Communication Act destroys data? Not the officer by him or herself, because there's the digital footprint. It must be done, Commissioner of Police, TTDF, with the advice of the Director of Public Prosecutions. Don't take my word for it. Look at the legislation itself. Look at the Interception of Communication Act time that we see in Section 20. And watch. Section 20. The Commissioner of Police shall consult with the Chief of Defence Staff, the Director of the SSA, and where he considers it appropriate, the Director of Public Prosecutions prior to destruction. That's what you call recognizing that the law speaks to balance. Honourable members, this act, as we propose to amend by the bill, seeks specifically to operationalize another important section, and that is in relation to the financing of the SSA. Serious crime to be operated by services, to be balanced by constitution and interarticulating laws, functions specifically to allow for training for the first time to be given lawfully under an umbrella structure to all of the services. Services is defined. First time, but specifically, we say that we should amend Section 9 of the Act to allow for monies to be received from the seized asset fund established under Section 58 of the Proceeds of Crime Act. What's that all about? Under the Proceeds of Crime Act, the Minister of National Security is obliged to create a seized asset committee. The seized asset committee is obliged to suggest what monies which go into that pot and which are disaggregated from the consolidated fund and stay in that pot are to be used for social activities, law enforcement training, law enforcement activities. Would you be surprised to know that even though the Proceeds of Crime Act has been floated by way of amendment for umpteen years, let's look from 2009 come forward. You know the first time a seized asset committee was comprised and formed was under this government in this incarnation? No intent to operationalize the law, but specifically the amendment before you as proposed to Section 9 speaks to allowing for the law to go to work for assets to be lawfully dealt with under due process and then come into the seized asset pot and to be applied for bona fide purpose so that we can then build an enterprise, not by ourselves, but as CFATIF advocates, and I confess I'm the chairman of CFATIF this year, as I advocate as chairman on behalf of Trinidad and Tobago for a regional operationalization of seized assets committees. It's why on our published legislative agenda, one published for the first time in 6 years, we have listed civil asset forfeiture, we have listed amendments to the Proceeds of Crime Act, etc., as priority items because we intend through due process to enable the law enforcement investigative authorities and prosecutorial authorities to hunt down money laundering, corruption, and criminality. Trinidad and Tobago, Madam President, is numb to the allegation that there's no consequence to crime. You can say and do anything. Thank you, Madam President. You can say and do anything, it seems, and nobody will suffer the consequences. Is that perhaps not an allegation as to why our country seems to have no real resolution in its pursuit to deal with issues? Madam President, Trinidad and Tobago has to look at the argument of proportionality. This time doesn't permit me to go into the full argument. Suffice it to say that in discussions with the criminal justice advisors to the government who operated for the past government and this government from international agencies as well, there is no expressed concern in relation to the operationality of this act as it is intended to be operationalized by way of amendment. The position put before honorable senators is that this law has a legitimate aim to treat with security and serious crime. It intends to operationalize the unoperationalized obligations we have under international treaty, especially in relation to UN Resolution 1278, which we signed on to deal with anti-terrorism and its financing. The law does not seek to intrude any much further than is required by way of intrusion, and in the event that one thinks that the law intrudes beyond its scope, I invite honorable members to consider the law is not being changed in a vacuum. It is being operationalized with the architectural support available to us through the Constitution, through the intersecting pieces of law which work in tandem with this, such as the interception of communication legislation, etc. We seek to pour the cleansing light of public scrutiny before us, sitting at the public accounts of Trinidad and Tobago by the Auditor General on the table of the Parliament, these large volumes. What do those mean? Is not the Auditor General an important creature under our Constitution to be invited in to look at the whole of government operationality as opposed to silos? If I sat down today and the government said we will not pursue this bill, is it status quo? Do we just operate the way the last government did or previous governments before that? Because it surely isn't only the last government. Is there a serious issue in our country that we must attend to right now? I invite honorable members to think as to the proportionality argument. Is there balance? Is there perspective? Do we accept the opposition submissions, notwithstanding report after report in writing under their own hand, in their own cabinet, in their own National Security Council, under their last Prime Minister, which say SSA Act is good, let's run with it. Let's use it exactly as it is. And do we now listen to their arguments, as I anticipate they will be made, to say, well, don't do as I wrote. Don't do as I recommended. Just do as I say now today. Time for more analysis paralysis. The public interest must be factored against the law. The bona fide of moving our society forward must be considered. And I hope that honourable members will give fulsome reflection to the pinpoint arguments. I do intend to listen with great interest to the course of the debate, and there will be a lot to be said in terms of wrap-up. I'm available to answer any issues that honourable members may have. This is not a closed-door session. It's why we have bothered to be as public in our interactions, whether we surveil statistical information, whether we have consultations on the prison system, notwithstanding criticisms by my learned colleague, who I welcome to the Senate. I'm glad to see him, Senator Ramdeen, today. I've heard you on the public utterances in relation to some things which I find quite remarkable, but that's all part of the course. But the point is, we are here to listen. It isn't a one-way position. But we do believe it's high time that our country progressed its national issue of combating and beating the scourge of crime before us and meeting our international obligations in a meaningful fashion. I beg to move, Madam.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Strategic Services Agency Act, Chapter 1506, to expand the functions of the Strategic Services Agency be now read a second time. Senator Mark.
Very much. Madam President, I would like to begin my contribution on this very important measure before this Senate, which is the SSA Amendment Bill 2016. I almost go to say the SS Bill of 2016, with a famous and provocative poem written by one Pastor Martin Naimola during the Nazis' rise to power and the subsequent purging of their chosen targets, groups after groups. Hear what Martin Naimola left for the history and legacy of humanity. First, they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak out for me. Unlike Pastor Martin Naimola, we in the People's Partnership intend to speak out and not allow our voices to be silenced or stifled by modern day Nazis.
46-4, Madam.
Madam President.
46-4.
Continue, Senator Mark.
Madam President, what is before the Senate as amendment to the SSA Act is not in law or fact, an amendment. But really a new act disguised as an amendment in order to prevent this government from bringing an act that would require a special constitutional majority, which they know in its present form they will not be able to secure. Instead, what the government has chosen to do, Madam President, is to engage in cherry picking. It is a cherry picking exercise which I hope would satisfy the ultimate objective and not meet the standard requirement necessary for the passing, as my good friend said, of good law, for the peace, good order, and good government in the interest of the people. Madam President, we shall attempt to clinically and surgically examine this bill and advance for the consideration of this Honorable Senate some of the best practice that we have been able to access, apply our intellectual rigor to this exercise, because in spite of what one can describe as a sloppy drafting, Madam President, the manifest deficiencies and the absence of appropriate mechanisms of accountability designed to safeguard the public fundamental interests, as well as innocent citizens from abuse and misuse of power and arbitrary and capricious abridgment, breach, and violation of citizens' fundamental rights and freedom. Especially, I want to disagree with my honorable friend, especially the fundamental human right to privacy. And I hope, Madam President, in his usual style, I know he's under some pressure these days, they have put him out to roast, but it doesn't matter, he's going to get my full protection. Madam President, I hope that my honorable friend, will take on board at the end of this debate a number of important considerations. I hope so. Because if he does not, I want to remind him of a very important quotation from the late Harold Wilson when he said, "He who rejects change is the architect of decay." The only human institution which rejects progress is the cemetery. End of quote. So we hope that when we put forward proposals and suggestions that the Honorable Attorney General would be open, Madam President, to accepting these proposals. We would like to early flag the need, Madam President, to have this matter referred to a select committee of the Senate. We want to flag that very early. We want to suggest that we send this matter to a select committee of the Senate for deliberation and complete airing, because there are fundamental issues that are involved. Madam President, I want to tell you Article 12 of the United Nations Declaration of Human Rights states, and I quote, "No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation." Everyone has the right, Madam President, to the protection of the law against such interference and attacks. End of quote. Madam President, in the absence of any credible or meaningful mechanisms of accountability and or systems of checks and balances and safeguards to prevent abuses and the misuse of power by the authorities, it is essential that this honorable House take pause for a worthwhile cause. Madam President, the expanded remit of the SSA in Clause 4 will lead to an invasion of one's privacy and without even one knowledge of that invasion. Madam President, privacy enables us to create barriers and manage boundaries to protect ourselves from interferences in our lives. Privacy helps us limit who has access to our bodies, to places and things, as well as our communication and information, Madam President. It is the right to know that one's personal communications, medical records, personal data, and bank details are secure, Madam President. Privacy is essential to human dignity and autonomy. In any society, Madam President, the right to privacy is a fundamental human right, and solid grounds must be advanced if it is to be trampled or tampered with in any way, Madam President. Madam President, we know as a fact that the threat of terrorism is giving governments across the globe carte blanche to ramp up state surveillance. Industry is voracious, Madam President, in its appetite to profile people, to predict what we will do, and to profit from our data. It is our firm belief that technological development should strengthen rather than undermine the rights to private life. And everyone's privacy must be carefully safeguarded, Madam President. We need, Madam President, appropriate safeguards to prevent rights abuses. Madam President, an important element of the right to privacy is the right to protection of personal data. While the right to data protection can be inferred from the general right to privacy, there are specific international and regional instruments, inclusive of our own Data Protection Act, Madam President, which stipulates a more specific right to protection of personal data. That is law, although some aspects of it have not been proclaimed. Madam President, I raise these matters to highlight the need for extreme caution and sensitivity and care in expanding the reach of the state as it seeks to fulfill its international obligations. As it seeks to detect, prevent, and overcome the serious crime scourge and seek to balance the rights and freedoms of the citizens vis-à-vis the security and safety of the state. Madam President, measures should always be proportional. My friend talks about proportionality, but we are discovering how disproportional this thing is before us. That is the legislation. Madam President, I want to go further. The European Convention on Human Rights, under Article 8 states, and I quote, "Everyone has a right to respect for his private and family life, his home and his correspondence, and there shall be no interference by a public authority with the exercise of this right, except such as in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or economic well-being of the country, for the prevention of disorder or crime, or for the protection of health or morals, or for the protection of the rights and freedoms of others," end of quote. Madam President, there must be a measure of legal protection in law against arbitrary interference. Arbitrary interference by public authorities, especially where a power of the executive is exercised in secret. This is what is crucial here. This is being exercised in secret. The risks of arbitrariness are more real and evident in such an environment, Madam President, where a law confers a discretion. That law must also indicate the scope of that discretion. It cannot be a case of unfettered power by the executive. Madam President, any unwarranted and uncontrolled arbitrary invasion of privacy through interception of communication may even serve to compromise a person's right to a fair trial. We must prevent Big Brother from becoming the masters of citizens' private life. Today, Madam President, interception of communication without a warrant is equivalent or tantamount to interference. The state cannot enjoy an unlimited discretion in its drive to intercept one's communication. And it's being, Madam President, as is being proposed in this legislation. And therefore, I think it's important that the AG pay attention. It's an old case, and I think I want to study law now. But it's an old case. But I asked the AG to refer to the James Malone versus the United Kingdom judgment, which was handed down by the European Court of Human Rights. I think it's a case that you would do well to study during your period in the Senate, Madam Vice President. Madam President. Madam President, we are very clear in our minds, and I would like you to join me as I seek to examine the absolutely fertile soil for these abuses.
Madam, just point of order, please. I know you invoked 4210 a while ago, but I just want to give you indulgence on that.
Senator Mark is referring extensively to his notes. I will allow it, all right? I will allow Senator Mark to continue.
Thank you very much, Madam President. Madam President, as I said, we want to look at this matter because in the absence of what is called appropriate mechanisms of accountability, there is going to be room for arbitrary intervention by any agency of the state. And I want, Madam President, later on in my contribution, to make reference to the former leader of the opposition, now Prime Minister, when he debated extensively in the other place on this bill that was referred to earlier, the Interception of Communications Bill. And he made very important reference to the systems of accountability that ought to be established to avoid that kind of incursion by executive authority in the lives of citizens of this country. Madam President, in view of the expanded remit of this particular legislation, Clause 4 of the bill gives a very expansive definition of serious crime. Initially, the SSA was designed, Madam President, to deal only with drugs and drugs interdiction. We are now expanding that authority to other areas, Madam President, and I don't have to detain you, Madam President, it is there in the interpretation section as to what serious crime includes and what are the offenses involved, Madam President. And therefore, in these serious areas that we have outlined, there is the possibility, the real possibility of political influence. And when we go, Madam President, to Clause 3.3 of the Parent Act, Madam President, we see, Madam President, under Clause 3.2 rather, of the Parent Act, that the functions of the agency shall be exercised by the director after consultation with the minister. So even though, as my friend is saying, in 2010, the SSA was included in the Interception of Communications Act, but that was only for drugs. In 2016, you are now expanding drugs to include several other categories falling under the rubric of serious crime. That is what you have done. And that is a fundamental difference between then and now.
Yeah, there was no interception of communications.
So, Madam President, here it is. You have a director who is a civilian appointed by the politicians. I have nothing against Colonel George Robinson. He is now the director. But who was he appointed by? He was appointed by the cabinet of Trinidad and Tobago. And when he was appointed, these functions here, treason, homicide, terrorism, terrorist financing, money laundering, and a host of other specific offenses were not included. He now has a larger remit. But yet still, he has been appointed by the president, in this instance, the cabinet. Madam President, and what is even more alarming, the director, after consultation. So let's assume that this director, before he could even take action on any matter, he has to first consult with the minister. So let's assume that one of their own was involved in some kind of nefarious act. He must now first consult with the minister and say, Mr. Minister, X or Y is involved in X or Y. Can I pursue? He says, no, go for the other one. Madam President, that is what you're talking about. You are giving this individual a power to abuse power. And there's no checks and balances in this particular act. None. Madam President, the director, it goes on further, is to be appointed by the president, as I said, and he shall be subject to the directions of the minister, which is essentially the prime minister. The prime minister is the chairman of the National Security Council, and the minister of national security reports to the prime minister. So if the prime minister does not like X or Y, and the director has to take directions from the Minister of National Security, who is de facto the Prime Minister, Madam President, we will have a police state here. And that is why we are saying, Madam President, we need checks and balances to ensure that there is no arbitrary invasion of the privacy and the spaces of the citizenry of this country. We need checks and balances, Madam President. Madam President, I want to tell you, I read with alarm personal financial data in one newspaper 2 Sundays ago, where the HDC provided, I understand, and I want the Attorney General to investigate this. I want the Attorney General to investigate how an Express journalist, Madam President, was able to come into contact with 900 pages of personal financial data of persons who apply to the HDC for housing. Where did she get that data from? My information, it came from the boardroom. And I am calling on the Attorney General to tell this country what was the role of the chairman and the board of directors in the releasing of this information to this journalist. What was the reason? And Madam President, if you are talking about coordinated information and you have to analyze information and you have to collect, gather and analyze in order to transform it into intelligence, and this is how the PNM has begun to use information for mischievous purposes and then attack the whole police service. Special branch attacked. Other police officers attacked. Because of what? They get a house, which is a normal thing that happens throughout the history of this country. But they use the information for mischievous purposes. So, Madam President, I am asking, when we talk about communication, and this particular officer, the SSA director, has the authority to intercept communication. Madam President, you know what they are talking about, Madam President? Madam President, communication means anything comprising speech, music, sounds, visual images, data. They can hack into your email. They can hack into your Facebook account. They can hack into your Twitter account. Because, Madam President, under the Interception of Communications Act, the SSA director can intervene on grounds of national security. And what is that ground? Madam President, it is as broad as it is wide. It is as broad as it is wide. And we cannot sit here and allow the government of Trinidad and Tobago to bring a measure and to allow the Attorney General to come and try to mama guide the population.
Senator Mark.
Madam President?
Withdraw that part about mama guiding the population, please.
Well, we will not allow him to mislead and misguide and misinform the population.
Senator Mark, I didn't hear you. Withdraw it.
I withdraw. But I will not allow him to misinform and misguide and mislead the population. So, Madam President, it is clear to us that this bill is either withdrawn in its current form or it is sent to a select committee to be completely redrafted. It cannot go in its present form, Madam President. And I am not buying no argument without any information. The Attorney General said he's the chairman of FATF, and he has a report, and we are on this enhanced list in terms of sanctions, possibly in July. Where's the report? Where's the report? So we are debating a matter, and we don't have a report before us.
In the dark, yeah.
I want a report.
Where's the transparency?
No, don't pop your hand now. Circulate the report.
It can't be circulated, and you know that.
All right, but if it can't be circulated and so on, don't come and tell us we must compromise our rights. We are not prepared, Madam President, to compromise people's rights on some flimsy basis. No. You have to be serious, man. You have to be serious. This is a double-edged sword. This is for FATF, and this is also directed at journalists. This is also directed at politicians. This is also directed at opposition members. It's a double-edged sword. It could go anywhere. It cuts both sides. So, Madam President, we are saying that this strategy that the government has advanced today is a political one, and it is designed, as far as we are concerned, to undermine the office of the police commissioner. We think that this present measure will undermine the police service commission as well. We think this is so too. dressed up in appropriate legal garment. Madam President, it is clear to us that the director of the SSA, Madam President, not this one, but past, Madam President, for 21 years, and I want the Attorney General to tell this country, Madam President, if you go to 14, Section 14 of this Act, it says that the government shall make, the SSA shall make regulations and have those regulations tabled in this Parliament for negative resolution. Madam President, it is 21 years since the SSA has been established, and 21 years have passed and no regulations have been tabled in this Parliament for 21 years. That is why, Madam President, we could read in the papers, Madam President, that 75 people have been fired from the SSA. Every day reading the papers, you're hearing people being fired left, right, and center. Because the reason, Madam President, is because under this section of the Act, they are supposed to establish in regulations the provisions that deal with the conduct and discipline of employees and establish a disciplinary procedure. Where are these procedures after 21 years? So, Honorable Attorney General, bring the regulations in select committee before you take this thing further. Bring the regulations. So, Madam President, we are not buying this talk. And, Madam President, may I, as I'm on this point, may I ask through you, Madam President, I looked through the Act, I saw no provision for a deputy director of the SSA. Yet still, I saw the Minister of National Security looking around some time ago, but he's no longer here. I would have asked him. Well, he was somewhere around, I should say. Spying. I don't know if he was spying. No, I withdraw that. He's my friend. I withdraw that, Madam President. But, Madam President, I saw in Sunday's Express, with your help and leave, May the 1st, 2016, where the SSA, before this bill could even be debated in this House, since the 15th of April, they went ahead and appointed a woman, a former deputy commissioner of police and former special branch head, Anne-Marie Allen Daly, as a new deputy director, administration. And, Madam President, there is no provision in the law for deputy. I know a deputy that says essential. I hear somebody said, Madam President, that a deputy is essential, but I don't know how essential this is if it is done illegally. So this is a very brilliant lady. I have no question about the competency and capability of this lady. She's a very competent person. But, Madam President, it goes further. It says alongside her, former Lieutenant Colonel Claude Bridgewater is also appointed as Deputy Director of Intelligence Operations. Where have these two appointments come from? Could the Honorable Attorney General point out to us in law where these appointments derive their status, their statutory validity? So we may possibly have already an illegality taking place at the SSA as we speak. An illegality. And Madam President, you know what is even more serious? The Honorable Minister is quoted as saying, all appointments in this story at the SSA have to do with his knowledge. So he knows every person who was appointed at the SSA. He knows about these two deputy directors and others. So it tells us again, Madam President, that here it is. The government is appointing an organized body which is going to be accountable to the Prime Minister. And I want to debunk this argument this Honorable Attorney General raised about accountability within the parliamentary framework. We want to have a real accountability body here. We have a joint select committee on national security. It has frozen in time.
That's right.
We have, Madam President, is a senior cabinet minister who is in charge of that committee. And I understand that committee has met twice, if so many times. And we have always objected to cabinet ministers being appointed to head these committees. And you are telling us, accept your word, we have a mechanism for accountability. Who are we going to accountable? Who are we going to use to account, or how are we going to get the SSA to come before us, Madam President, and properly account? Through a cabinet minister who is not meeting? Madam President, I want to tell this honorable House that we want to tell the Attorney General, you have to withdraw that cabinet minister from that position and either appoint a member of the independent bench to head that, or you appoint a member of the opposition bench to head that JSC on national security. You can't, Madam President, this is gimmick. We are not serious. And then he comes here and boasts about mechanisms of accountability and safeguards. How we can get safeguards when a cabinet minister is accounting to himself? So, Madam President, well, no, he doesn't sit by himself. I'm saying, in all civilized country that you are aware of, and this argument that has been advanced by this Attorney General, that 97% of the bills that we brought here, whilst we were in the PP, supported. I want to tell you, Madam President, that is a myth.
Really?
I want to tell you that every time a bill was passed in this Parliament with the support of the PNM, hundreds of amendments were put forward. No bill was passed in this current form. Our Attorney General, our current Attorney General, always brought a slew of amendments to strengthen, Madam President, the legislation. This is right. And that is what we are doing today.
Senator Mark, you have 5 minutes.
And Madam President, that is what we are doing today. We are bringing a lot of, two things we are doing. We are asking you, Honorable Attorney General, to have this matter referred to a select committee of the Senate. And at that select committee, we intend to propose a series of amendments for the consideration of the Parliament. Madam President. So Madam President, we are saying that the measure before us today, we want the Attorney General and Minister of Legal Affairs understand that there's a document which I intend to circulate to you, Madam President, and to him and to this Honorable House. It is a United Nations document in 2010 that deals with best practice when it deals with intelligence services and the kind of oversight mechanisms that the United Nations is proposing if we want to have these intelligence services unaccountable to the people of any country. I want to provide this copy to the Honorable Attorney General and to members of this Honorable House. So, Madam President, we are, and we would like to strengthen the legislation, but we must be given the opportunity to do so. If the government is not prepared to have this matter referred to a select committee of the Senate, if the government is not prepared to entertain meaningful amendments to strengthen the legislation, Madam President, the next alternative is for the government to withdraw this measure. This measure in its current form is not going to fly because it violates our Constitution, it violates international law, it violates the Declaration of Human Rights, and there are sufficient cases. I think there's another case called Kennedy, Mr. Attorney General, Kennedy. And you have Malone. So you have a lot of homework to do. Malone and Kennedy. Let us do, Madam President, what is right. Let us make sure, Madam President, that we put together legislation that is acceptable, that is palatable, that is meaningful, that will safeguard the rights and interests of the people, and at the same time, Madam President, balance the safety and the security of the state. We want to ensure that criminals are dealt with. We want to deal with them. We want peace and security for our people, but we will not stand idly by and allow the government to use crime and runaway crime to bring dictatorial measures, draconian measures to undermine the rights and the freedoms of the people of Trinidad and Tobago. We will not do that, Madam President. We will work with the government to strengthen the legislation to ensure that these balances are established. But at the end of the day, Madam President, we want good law, we want good order, we want good government in the interest of the people of our country. And I want to close by reminding the Attorney General that in this country, we all are living here together as one family. And we want to ensure that whatever we do, we do not make laws for today, but we make laws for future generation. And Madam President, in closing, freedom is never snatched away in chunks or large amounts. Freedom is always eroded and whittled away incrementally and gradually. And this government is using a bill to begin the erosion of our fundamental rights and freedom. And we have discerned it, we have identified it, and we are saying, Madam President, the time has come for the government to step back, withdraw this bill, refer it to a select committee if it wants to, but it cannot go in its present form. I thank you very much, Madam President.
Yeah.
Thank you. Thank you, Madam President. As I join in this debate, I must say it is a most pleasant experience once again to see the Honorable Attorney General in the chamber. We have had many interactions, and today is, I'd imagine, not going to be different. Madam President, in this particular amendment, I want to refer to the Parent Act. Parent Act 1506 of 1995. The SSA now is in existence for over 20 years. And under 61A of the Act that we are seeking to amend, under the Parent Act it states, Madam President, and I must read, the main functions of the agency are to A, act as an office for centralizing information, that could facilitate the detection and prevention of illicit traffic in narcotic drugs, psychotropic substances, and precursor chemicals, for coordinating operations for the suppression of illicit drug trafficking and drug-related matters, and for cooperating with the services or the corresponding services of other countries. This, Madam President, was established in 95, October the 4th, to really supplement our police force. Before the SSA, we relied on the police force of Trinidad and Tobago to engage in its own intelligence gathering operations so that it will be able to identify and bring to justice drug traffickers in this country. Over the last 20 years, what have we seen? We have seen that the police has been relatively successful in the area of drug trafficking offenses with respect to the small bit players on the pavements, on the streets. In fact, it is my understanding that there are a number of individuals in our prisons who are incarcerated because they were peddling relatively small quantities or perhaps using small quantities of the various narcotics which are currently illegal according to our statutes. But, Madam President, the SSA then, if it left the small players to the police because they are easy to observe visually, and we could shake them down and physically collect the rocks and the joints that they have in their possession, we ask ourselves, clearly the division of labor dictated that the SSA would concentrate over the last 20 years on collecting information on the large players in the business. Madam President, we frequently hear of the Medellin cartel. My interest in it is a cartel. A cartel is a relatively small number of players, as OPEC has, where you could come together, agree on pricing and output strategies, and you could easily identify them. And when I saw the amendments brought by my friend, the Attorney General, for whom I have tremendous admiration and deep affection, and for whom I have locked horns perhaps only once, where I think I won in the period of time that we interacted, and we frequently collaborated. When I looked at the amendments, I asked myself, I said, shouldn't the Attorney General have taken another look at the SSA to ask the following question? Given that at any time there perhaps are maximum 12 large drug players in Trinidad and Tobago, could it be 5? Could it be 10? Could it be 15? Let us say there perhaps in Trinidad is a maximum of 12 players. The police force deals with the little guys. They bring them to the magistrate's court, and the magistrates will give them 3 months and clog the prison system. But shouldn't the SSA, over the last 2 decades, have been able to identify 1 or 2 or 3 of the 12? Madam President, what was disappointing to me from where I stand is this. Not so long ago, there was a major drug find in Boston, from Trinidad and Tobago, in juice tins, in a liquid form, worth millions and millions and millions. It made the news for a while, and then it disappeared, tarnishing the reputation of our country. And I said to myself, since we have an SSA that is charged with monitoring 12 of them, 5, 10. I don't know how many. It couldn't be large. We know there are many people on the ground, but a few at the very top. Should the SSA not have been working, because it is charged with prevention of illicit traffic in narcotic drugs, centralizing information, and cooperating with the services or the corresponding services of other countries? Shouldn't the SSA have given me, as a regular citizen, some assurance, Madam President, that it had all the information on that Boston drug find from Trinidad, that it shared with the DEA of the United States as it is charged to do under the SSA Act of 1995, so that as a citizen, I would have some comfort in knowing that here we have an agency that is able to collate the information, share it with an international agency, and bring to court a case where there could be a prosecution. To this day, we do not know who the players are in that cocaine-induced fines, and to this day, the file has gone cold. Where was the SSA? What has been, Madam President, the success of the SSA in discharging its functions, in identifying the mega players in the narcotics field over the last 20 years? And Madam President, there is in the business literature, Senator Shriki Soon will be most au courant with it, something known as the cockroach theory. It was identified by Warren Buffett, and he said this, and it applies in all areas. When you see one bit of bad news coming out of a business, assume that that is a cockroach. There are many other bad bits that the management did not tell you. Here we have one cocaine find. How many pass through our shores on their way to other destinations, undetected and unfound? I am not convinced that the agency, Madam President, has been very effective in discharging the one function we have asked it to do. I will speak from now until in hell there is, Madam President, a snowflake on this matter, that we need to strengthen institutions in Trinidad and Tobago. The SEC, Securities and Exchange Commission, you will hear it from this bench over and over. In the last 20 years, established at around the same time, in the last 20 years, has not brought a case for prosecution, far less secured a conviction. And the FCB IPO, we are told it takes time. It has gone cold. I am sure now, nothing like that cocaine find, nothing on the FCB IPO will materialize. And Madam President, I think given the glaring facts, I thought that the Attorney General was going to come to Parliament with respect to the SSA to ask me as a member of the public with no axe to grind with the opposition or the government, asking me as an independent senator to strengthen the institution, because maybe we need to change some laws such that there could be more cooperation with the United States DEA or the British or the European and the international drug interdiction agencies. And if we needed to amend our laws to give other people a right to enter and operate in Trinidad, to train our officers, I would say fine. But here I am being asked to give an agency, Madam President, jurisdiction not only on drug interdiction, which it had demonstrated to me no capability in discharging, and we are now promoting it to do the following. Well, you can't identify who the big players are, so okay, let me add to you homicide, treason, terrorist acts, terrorist financing, hijacking, kidnapping, and a whole slew of activities. Is it that we are on the wrong direction? Madam President, as far as efficiency is concerned, I cannot support this measure. I think it would be much more practical for us to strengthen the agency so that it will be able to discharge its one function and not to burden it on things where I see, Madam President, a tremendous scope for mischief and an injury to the public. Madam President, let me look again on, and I heard the Honorable Attorney General with respect to Interception of Communications Act and so on. But let me again quote and emphasize one word from 6.1 of the Parent Act. The main functions of the agency are to act as an office for centralizing information. Information, Madam President. Information now, I am asked to include treason, homicide, terrorist acts, kidnapping, trafficking in children, illicit trafficking, psychotropic substances. And then what worried me what worried me is slipped into here is corruption and cybercrime. Madam President, when I read the list of all the crimes here, I think an agency can just identify every single individual in Trinidad and Tobago and say, I am going to monitor you, I am going to monitor your emails, I am going to monitor your conversations. In fact, I got worried. They won't get Mahabir, Senator Mahabir, on corruption. They won't get me on cybercrime. They may get me on treason. They may say, this guy has been voting against the government on a number of bills, and he's treasonous. Let me monitor his conversations. Let me monitor his emails. Let me track all his correspondences. Madam President, this is not the Attorney General, you know. This is not the AG. This is, as Senator Mark rightly indicated, the director of the SSA, who has now a responsibility for centralizing information. This information has to be collected. Madam President, it doesn't have to be that the SSA is collecting the information for all of these crimes. Somebody then has the authority to collect it, as long as the SSA says, director of the SSA says, well, I am duty charged under the amendment now to include serious crime. And it says, or any offense which carries a penalty of not less than 5 years imprisonment. So that there are many crimes. When you read all the red books they gave me, the laws of Trinidad and Tobago, there are many crimes, car theft and so on, can carry that kind of penalty. And yeah, you have a lot of those crimes. So it gives this agency a wide scope, either to listen in on its own or to subcontract to some agency. And Madam President, I ask myself, where is the separation of powers? As a private citizen, I always held the view that if someone is to listen in on my conversation, if someone is to invade into my private space, there should be some intervention from a judicial officer and not an officer of the government. But Madam President, now let me refer to the Constitution. I have had occasion, Madam President, where senior counsel have sent legal opinions to me in a joint select committee. And to this day, I want to put on record, I have not read it because I do not understand legalese. I am not a lawyer. But you see, the Constitution, Madam President, is written not for lawyers. The Constitution is written for me, the regular person. And in reading the Constitution, let me focus on rights enshrined. Rights enshrined. It is hereby recognized and declared that in Trinidad and Tobago, they have existed and shall continue to exist. 4C, the right of the individual to respect for his private and family life. Let me focus on private and family life. I have heard the Attorney General indicate that we don't have a right to privacy. But Madam President, permit me if I were to read, because I suspect some of what I have to say, recorded in the Hansard, may have to be argued in some other place. Let me indicate, when I read this in the Constitution, this is what I interpreted it to mean. The right to a private life, to me, is the right to keep a domain around me, a sanctuary, which includes my home, my thoughts, my feelings and secrets. And I should be able to control which parts of this domain can be accessed by others. And Madam President, when I looked at the right of the individual to respect for his private life, I think the Constitution, when we read the Constitution as ordinary people, the Constitution tells me that I have a sanctuary. It tells me that I am not someone who is operating and living my life at the whim of the state. I have a sanctuary, and that sanctuary is my home. I am entitled to a space where I will be left alone. Madam President, in American jurisdiction, in the American system, there is a statement that what is whispered in the closet should not really be broadcast to the world. That I have a right to have a closet. I have a right to my living room. I have a right to a circle of friends. I have a right to speak to them. I have a right to send an email to individuals who are not concerned about how I function at the level of the state. And that is my property to keep. No one should be able to invade my private space without my permission. But what the law does is that it creates a potential for mischief. Not the intention of the Attorney General, but it creates the potential where, given the expansion of this intelligence information gathering agency, we have a situation where the legitimate expectation that I have, as indicated to me by my understanding of the Constitution, which is written for me and not for senior counsel to argue in the High Court. This is written for me to understand. What do I understand? And the hundreds of thousands, the 1.3 million people in Trinidad understand when they say you have a right of the individual to respect for his private and family life. Well, let us focus on the word respect. What does respect mean? It is not put in the Constitution there simply because there is a need to add to words. Respect really means something or someone in high regard. We show respect to someone's family life and respect for someone's private life. Can you have someone having a private life and then someone showing no respect for it? The Constitution says, let us show respect. And by whom? It has to be by agencies of the state which may want to intervene in the private life of an individual, and therefore it interferes with his private space, his sanctuary. We could quibble from now until a long time on whether private life means privacy or not, but for me, reading the Constitution and acting now in the public interest, I am very reluctant to give an agency a power to use any excuse so that it could invade that sanctuary which is given to me by the Constitution. And I understand that there are circumstances in which, Madam President, an individual's private space and a sanctuary will have to be invaded. The circumstances are that there is just cause for thinking that this person is up to harming the society. He is not just living his life in his private space. He is plotting with others, and we need to listen in. And therefore, invasion of the private space has to be justified. It has to be warranted. Hence, we have the use of a warrant. Warranted, it has to be justified. You simply can't, because we have Israeli spy technology, because we have technology to track email, because we have the technical capability to observe and eavesdrop and to know what someone is doing, that we have the right to do it. We don't. We are encroaching upon the private space of the person, and we must enter that private space with respect. The Constitution says respect. We must respect it. We must not act as though that private space belongs to an arm of the state. Respect in high regard. You have to show consideration and you have to show due process. Madam President, let me focus on another area of the Constitution that I would like to emphasize with respect to my disagreement with this bill. When I looked at the rights again, I see under 4I, there is freedom of thought and freedom of expression. When I examined constitutions around the world and I tried to find out the bases of where these came from, it exists in many constitutions. Freedom of expression, we know. Freedom of speech. No one should be able to muzzle me given an opinion I have. I should be able to say what I have to say as long as I am not libeling someone. But what does freedom of thought mean? And what is the relevance of freedom of thought with the amendment that the Honorable Attorney General is advancing for consideration of me and members of the Senate? The freedom of thought for me, when I read it, gives me the right to contemplate ideas, Madam President, which, if expressed in the public domain, can lead for me ridicule, loss of stature, and even ostracism. I have a guarantee under my constitution, Trinidad and Tobago's constitution, that I have freedom of thought, and I can contemplate, pontificate, ponder things which, if they were to go in the public domain, can bring me ostracism or ridicule. Take, for example, Madam President, recently in the news, there is an issue of abortion. It is contentious here, settled in some of the advanced countries. Someone in our country may belong, Madam President, to a particular faith, which says that even thinking about abortion is unacceptable. You could be excommunicated. But the Constitution says, since we're a secular state, Constitution says you could be a member of that religion. But if you think that, Madam President, if you think that abortion is acceptable in cases of rape and incest and danger to the health of the mother, then you are free to so do. But underlying my reading of the freedom of thought is that sanctuary I spoke about, the right of the individual to respect for his private and family life. It's not as if you are just able to think it and keep it to yourself. It implies, in my opinion, a domain, a sanctuary, a space where you are left alone and you are able to articulate this view to those in your inner sanctum. And it is not going to go out. It is, Madam President, in my mind, unconstitutional for an agency to be able to listen in to someone's conversations which may very well involve the thoughts he has, which may be in contradiction of popular opinion. And the problem with that is the potential for mischief and misuse. Madam President, I remember what happened in the Vietnam War. The United States was losing this war. Robert McNamara gave the directive, Secretary of Defense gave the directive, I want you to maximize head count. The American army could not find the Viet Cong, as the SSA could not find the drug traffickers. So what did the American army do? It killed out whole villages. And it caused, and you wanted head count? You will get head count. Madam President, the SSA can't really identify the major drug traffickers in Trinidad. What it will then do is that it will begin to gather intelligence on a lot of activities which I fear can be put to no good. Madam President, on efficiency grounds, I hope that the government, the Honorable Attorney General, who I suspect the friendship may diminish a little bit after today, but the Honorable Attorney General should, on efficiency grounds, look seriously at the situation where this agency has not been discharging its function. Madam President, I want to solve crime as much as anybody. I'm not being irresponsible.
May I just ask, just so I get the argument correct, thank you so much for giving me. Is it that you're gauging the lack of success, as you put it, for the SSA by the prosecution and conviction which the Trinidad and Tobago Police Service alone can do? Is it that?
Well, I would have thought, yes. To answer the Attorney General, I am saying, if they are going to really engage in, Madam President, drug interdiction, narcotics exercises, I thought the police force then would have gotten the data and the information from the SSA. So that if the SSA was doing its work, then the police force would have gotten all the information on the cocaine in drug tins, on the cocaine, not in drug tins, well, it was juice tins, they were drug tins too, and that there would have been, Madam President, no embarrassment to Trinidad and Tobago. That's what I'm saying. So here is an agency. You're supposed to collect data, to build a case. You're supposed to feed it then to the police. Over the last 20 years, I know of only one large case where a drug trafficker was brought to prosecution. That is the Dolce gang, and that was not for drug trafficking. That was for, I think, murder, some other thing. So, Madam President, the SSA, I am gauging its success by the fact that the big players in the drug field, which was the intent of the original legislation, the intent was to ensure that the police can deal with the little fellas and the SSA can compile the info, because we do need, Madam President, technical expertise. We need international sharing of information. Does the SSA have any major international communications with the DEA and the Russian and the European and the Indian and the Chinese? I would have thought that they would be able, at least, I come back to the cockroach theory. We didn't find that one in Boston, and I am sure there are many others which are going undetected. Madam President, on the basis of efficiency, I would have liked to see a strengthened SSA. Had the SSA been an agency which was showing major success in discharging its functions, identified for it under the Parent Act, then I would have no hesitation indicating to the general population that I think the SSA has grown and we could now move, because it has caught all the big fellas in drugs. All the big fellas to come, they will catch. And now let us move towards the treason and the kidnapping and the car theft and all that, because this agency is so good that it is now going to be able to help the police force gather the information that we need to prosecute crime. I have a suspicion and a fear and a worry and a concern that the powers we will give and the range of crime that I see under the new amendment, this agency has a power to collect information. Not that it will, as the Attorney General said quite rightly, collect it on its own, but it certainly has the power to collect information on almost everybody. I'd imagine only my grandmother would be exempt, because I don't see any crime here that you can reasonably charge the lady for contemplating, perhaps except smuggling. She may be smuggling something, coming through the airport and so on. Little old ladies can be charged for doing that, and you provide a justification that, yes, I will spy on this lady, I will collect information, I would listen in on her conversation. Now, Madam President, even that may not be bad. However, what is injurious to the public interest is, as Senator Mark alluded, the information so collected can be used by persons not to prosecute them for crime, but really to embarrass them about, in the public domain, their health status. They may be HIV positive, about their financial affairs, they may be heavily indebted and so on. It can be used wrongly. There is no guarantee in this particular piece of amended legislation that the information is not going to go into hands which will find its way into the newspaper or elsewhere. And therefore, Madam President, since on grounds of efficiency, I think the SSA needs to be strengthened before we add to it. And then, on what is contained in the Constitution, the right of the individual to respect for his private and family life, freedom of thought and expression, we need to be very, very careful has given technological change and the ability now to engage in activities which will be such that you enter into people's space. Let us respect the need for people to have their private space. Let us respect the people to have freedom of thought. Madam President, without freedom of thought, there can be no progress. We need our private space for freedom of thought. Without freedom of expression, there can be no liberty. I need to have liberty. And without my private space and without my privacy, I can have no life. And I would be living like in North Korea, where everything I do is under the scrutiny of the state. And Madam President, that's not the Trinidad and Tobago that I have come to learn to appreciate. It's not the Constitution that I respect, and I request that this bill be withdrawn. Thank you very much.
Senator Coppin.
Madam President, thank you for the opportunity to contribute to this bill. This bill deals with national security. And we all know that national security is perhaps the most important scourge to the national security, Madam President, is important to the way we live our lives, the quality of life of each and every one of our citizens, and we must deal with this matter as a matter of urgency. Madam President, permit me to commence my contribution by looking back at some of the remarks of the Honorable Senator Wade Mark. Senator Mark has become a bit of my good friend. We are on we are in several committees together, so his behavior here today is not a shock by any means. In fact, Senator Mark is, as we know, an alarmist person who at times lets his imagination run away with him. And, Madam President, I don't intend to engage in name-calling, however, but in preparing for my presentation here today, I had cause to go to the Hansard and to see what the leader of the opposition had to say, particularly about this bill.
Where?
In the lower house. In any event, Madam President, it is important to know, because we need to understand what exactly is the opposition's policy with regards to the SSA bill. And that is the crux of my argument today. Now, in the lower house, and may I refer to the Hansard of the lower house, Madam President?
Senator Coppin, yes, I will allow you, but your presentation cannot just be quoting from the Hansard, okay?
Well, Madam President, the opposition leader spoke about the opposition's support for the principle of this bill. In fact, she spoke to a depoliticizing of the issue. She spoke about the opposition having no problem with the purpose and the intent of the bill because, in fact, during their time, they had supported what was known or was proposed as the NIA. So, Madam President, it came to me as a shock when, lo and behold, Senator Mark comes here today and he somehow has an issue with the intent and purpose of this piece of legislation. So, Madam President, I want to refer specifically to some of the things Senator Mark had to say, because he spoke about the constitutionality of this bill, or that this bill was not constitutional, because it, in fact, in his estimation, expanded the powers of the SSA so wide that it required, in his estimation, a special majority. Now, Madam President, I thank you for the opportunity to refer to the leader of the opposition in the lower house, the other place. Because in that house, Madam President, and I quote, she speaks, "I do not agree that you are not giving operational day-to-day operations for the I do agree that you are not giving operational power, day-to-day operations for law enforcement to the SSA. And therefore, on that basis, it does not require a special majority." Madam President, this is in direct contradiction to what was said here today. So it appears as if the opposition does not caucus. One house says one thing and the other house says another thing. It begs the question, as the Honorable Joseph, former Attorney General Joseph Tony had said, who is your leader? Is it Senator Mark, or is it Kamala Prasad-Visesa?
It's Mark.
So she says, on that basis, that is the opposition leader, that the bill does not require a special majority. But Senator Mark thinks otherwise. She says also that the issue of constitutionality does not arise.
Madam President, I don't want to interrupt my colleagues, but
Is it a point of order you're invoking,
Yeah.
Senator Mark?
Yeah.
May I hear what the point of order is?
Madam President, I want to ask you to consider. No, it is not in the standing orders, but I know it's a practice. No, Madam President, it's a serious point. If somebody is not here to defend themselves, is it a good practice to allow, for instance...
Senator Mark. Senator Mark. Senator Coppin, please continue.
So, Madam President, it is public record. I understand Senator Mark may feel a bit of trepidation because he perhaps did not look and he did not understand what was said by his leader. But this is the crux of his argument, and he stood up here for a very long time, that the bill was unconstitutional. In fact, Madam President, Senator Mark goes on. He says, the bill as proposed breaches the fundamental rights to freedom, fundamental rights to privacy. Now, Madam President, the Honorable Attorney General, the learned Attorney General, who has done a law degree, not like my friend who plans to do a law degree, referred to his presentation, and he referred to in the lower house, the other place, about the right to privacy and respect for private life. He said it. And I know that Senator Sturge and Senator Solomon and Senator Ramdeen, when they take when they stand to give their presentation, they will all deal with that particular point. But for those, I just want to reiterate what the Honorable Attorney General would have said in his presentation. And he referred to the case of Surat versus the Attorney General. Now, Madam President, with your leave, I would like to speak a bit about that particular case, because the learning of Baroness Hale, who gave the judgment in that matter, is very instructive in how we deal with, or how we envision the rights for family life and other rights, which in Baroness Hale's estimation was not absolute. So, Madam President, Baroness Hale, in that judgment, she opines the constitutionality of a parliamentary enactment is presumed unless it is shown to be unconstitutional, and the burden on a party seeking to prove invalid is a heavy one. So what that means is that an act is presumed to be constitutional until it is proven otherwise. That is what she says. Now, this case of Surratt versus the Attorney General, it concerned the Equal Opportunities Act. The former government, PNM government at that point in time, quite remarkably and ironically, claimed that the act was not constitutional because it had not been passed by a special majority, and it had not been, a particular section 13 of the Constitution clause had not been put in that said act, therefore stating that the act would have been inconsistent with the Constitution. And it was on that basis that the past PNM government had objected to that act as being constitutional. A motion was filed, constitutional motion, and it went all the way to the Privy Council. And it was found by the learned judges, Baroness Hale giving the judgment, that in fact, that law was constitutional. And the learning is this, the ratio decidendi of that matter, of this case, was this. It could not be the case that every act of Parliament which impinges in any way upon the rights protected in Section 4 and Section 5 of the Constitution was for that reason alone unconstitutional. Legislation frequently affects rights such as freedom of thought and expression and the enjoyment of property. Those were both qualified rights which might be limited either by general legislation or, in the particular case, provided that the limitation pursued a legitimate aim and was proportionate to it, and it was for Parliament, in the first instance, to strike a balance between individual rights and general interest. Madam President, this is the Privy Council. So, Madam President, I say all this to say that when we are assessing whether or not a bill is constitutional, there is reasoning, there is learning on the matter. So, Senator Mark, in my estimation, is slightly incorrect when he comes to this House and says that this bill is automatically, or he suggests it is automatically unconstitutional. That is not the case. There must be a balance that must be struck between the rights of the individual and the role of the state in protecting another equally important right, the right to liberty and security. Now, those two rights, Madam President, are contained within the Constitution of the Republic of Trinidad and Tobago. And I want to quote the Constitution of Trinidad and Tobago for the persons listening and at home. Chapter 1, the recognition and protection of fundamental rights and freedoms, Part 1, rights enshrined. This is Section 4. It is hereby recognized and declared that in Trinidad and Tobago there have existed and shall come to exist without discrimination by reason of race, origin, color, religion, or sex, the following fundamental rights. And I want to quote the two rights which I believe are relevant in this matter. A, the right to life, the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process of law. That is one right. And the other right, which Senator Mark and Senator Mahabir would have also spoken about, was the right to the individual, or of the individual, to respect for his private and family life. Those are two rights. They appear to be, sometimes, there's a tension between those rights. There's a need to protect the security of individuals. At the same time, there's also a concomitant right not to do it in such a way that it constrains, it takes away the individual liberty of the individual. And that is normal, Madam President. So that is where the principle of proportionality, which the Attorney General so lucidly explained to this Honorable House, that is where we must strike the balance. And Senator Mark spoke to Article 8 of the ECHR, which also speaks to the right to to family life. And it is important because while he read it in its entirety, he did not, Madam President, focus quite enough in the qualification contained therein. And if I am allowed to quote from that right, Article 8, respect for privacy, family life, home and correspondence. It says, there shall be no interference by a public authority with an Article 8 right, except such as in accordance with the law and is necessary for a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, for the protection of rights and freedom of others. So contained within that said ECHR Article 8 is a qualification. And if one reads the judgment of Baroness Hale speaks about the qualified right of the individual. She specifically stated that it is not an absolute right. So, and why that is? It is obvious, Madam President, that it cannot be an absolute right for one to do as he must, as he pleases, because one's autonomy affects another person's autonomy. And as Senator, the leader of Senate Business would have said in a presentation on the Commissioner of Police bill, when we as individuals left the state, the primordial state, and we agreed to become enjoined, to become a member of a state, we did so primarily because we understood that by living in a state of primordiality, a state of being in the wild, one could not protect himself from the dangers therein. So we effectively decided to centralize some of the power within the ambit of the state. So we are no longer autonomous, totally autonomous creatures as if we are in the wild, Madam President. We are part of a civilized society, and therefore we are governed by rules and laws, and therefore there must be proportionality in what we do. So, Madam President, I say all this to say that when we are looking at the mischief of this particular legislation, we must ask ourselves, what is this legislation trying to address? And, Madam President, the Honorable Attorney General would have commenced his presentation here and in the other place, and he would have spoken to the rise in criminality that is currently plaguing this country. And Madam President, allow me to quote some of the statistics that I gathered from the police website, from the TTPS. Reported crime, and this is between the year 2014 and 2015. Fraud in 2014, 223. In 2015, 592. Wounding and shooting, 2014, 558. 2015, 600. Larceny of motor vehicles, 742. 2015, 785. Murder, 403 in 2014. In 2015, 420. Kidnapping, 994. 2015, 106. Narcotics, 436. In 2015, 453. So what we see, Madam President, is an escalation in the crime rate from 2014 to 2015. Would the opposition have us sit on our laurels while criminals run rampant in this country and do nothing. I call, Madam President, for the opposition, Madam President, to do as instructed by their leader to depoliticize this issue, to act not in their own interest, but in the interest of Trinidad and Tobago, Madam President. So, Madam President, I want to turn now to deal with a bit of what Senator Mahabir would have spoken about. And Senator Mahabir, being an economist, one understands his need to assess a bill within the ambit of efficiency and effectiveness. I understand. The issue, however, or one of the issues that I have noticed in doing my research, that it is very difficult at times to measure the costs and the benefits of surveillance type expenditure. And the reason for that is simple. One simply doesn't know, it is shrouded in such secrecy that one simply just does not know where the money is spent. And I think this bill, the way it is drafted, it will bring a lot more accountability and transparency to the process. Yes? So this is one of the great benefits of a bill, this bill as drafted. And, Madam President, I want to refer to some statistics that I would have gathered while doing my own research. And it has to do with government spending. Now, Madam President, government spending on the SSA has increased dramatically in the last several years. And it is very important that we understand what we are dealing with. The SSA was allocated $707.6 million in 2013 budget. Right, this was an increase of $30.3 million from the 2012 budget. Further, it was allocated $140 million in 2014. Revised 2014 expenditure, $110 million. And in the year 2015, $135 million. So, Madam President, we have an institution which we know we don't know much about. That is not very transparent, not very accountable to the public, yet we are giving them vast sums of money, Madam President. And for me, that is quite worrying. So, I understand what the Attorney General and his team has done and are attempting to do to bring a level of transparency to and accountability to the functions of the SSA as it relates to money. And I think it ought to be lauded. We ought to embrace such an attempt to increase transparency within the public sector. What we don't know, Madam President, because we know that there has been a degree of siloing of information, we don't even know that there has been a degree of duplication, but we don't know how much money the other agencies that are currently involved in investigation and intelligence gathering, how much they actually spend in gathering intelligence. And now that for me is very worrying, because the police service is engaged in intelligence gathering, so is the Defense Force. So I think 11 other agencies which the Attorney General would have mentioned in the other place. I think he spoke to the Custom and Excise Enforcement and Operations Unit, the Defense Force Intelligence Unit, Financial Intelligence Unit, Financial Intelligence Branch, a division of the TTPS, Integrated Threat Assessment Center, the Ministry of Foreign and CARICOM Affairs, National Coastal Radar Surveillance Center, and the Anti-Kidnapping Unit, the Crime and Gang Intelligence Unit, the Criminal Investigation Unit, the Homicide Bureau, the Cyber Crime Unit, the Special Branch Fraud Squad, the Organized Crime and Narcotic Firearms Bureau, Prison Service Intelligence Unit, the Counter-Trafficking Unit, the Immigration Investigation Unit. All of these, Madam President, have surveillance units, but we really don't know to what extent the money that we actually allocate to them goes to the surveilling and doing the exact same thing that the SSA is supposed to do, because there is no centralization of the information. So, Madam President, through you, Senator Mahabir, I think we ought to look a bit more deeper and have a critical look at the costs and benefits of leaving the SSA as it is, of not expanding the powers, of not, the cost of the status quo versus the cost of reform is something that we don't know, but we can surmise that there will be significant cost savings if we remove the silos and we bring greater efficiencies to the operations of intelligence gathering in this country. So that was on that point, Madam President. As it relates to the operations of the FIU, Madam President, Senator Mahabir spoke also about the lack of conviction rates, and the Attorney General was correct in standing up to point out that intelligence is but one part of conviction rates. There are so many other things that one must consider in looking at the conviction rates in a country. It is not only a function of intelligence, intelligence obviously being...
Senator Coppin, do you have much longer to go? You have used up 25 minutes already. You have 40 minutes altogether.
Yes, I want to take a break.
Yes, ma'am.
Okay. Yeah. So, honorable senators, at this time we'll take the break for the tea, and we will resume at 5:05, 5 minutes past 5. So this Senate is suspended until 5 past 5. Seeing that you're